Hello, everyone. Welcome to our second coffee hour of 2025, hosted by the Senior Counsel Division of the Hawaii State Bar Association. So today we have fellow board member Scott Makuakani here today to present about estate planning for geniuses. Scott is a graduate of the William S. Richardson School of Law of the University of Hawaii at Manoa, also a graduate of Duke University and Ka'u High School. He has been practicing estate planning and trust law in Hawaii since 1983. He is a past chair of both the Probate and Estate Planning Section and the Estate and Gift Tax Committee of the Hawaii State Bar Association, and he currently serves on the board of the Senior Counsel Division. With that being said, welcome, Scott.
Aloha. Thank you, Desmond. I'm coming to you this morning from beautiful downtown Kea'au, visiting the Big Island right now, and really appreciate this opportunity to be able to address the group. What we're going to be talking about is estate planning for geniuses. Now, if you don't happen to feel like you're a genius when it comes to estate planning, if you think you're an idiot or a dummy, they write books about that. Um, there is hope. Uh, Being a genius when it comes to estate planning really is more a matter of the mindset, the approach, than it is the IQ. According to Albert Einstein, an intellectual solves problems. A genius avoids them. So being an estate planning genius is all about knowing the problems that are likely to confront you and your loved ones down the road and figuring out how to avoid those problems. So let's start with the concept of what if I do nothing? Now, that's a very easy approach. As a matter of fact, when we did a very informal survey of the members of the Senior Counsel Division as to who had a current estate plan in place, um, interestingly, about 60% of us said, no, I actually don't, which is pretty startling when it comes to a group of lawyers, and especially senior lawyers. But if you think about the general population, it could be at least that. Now, that 60% figure is very anecdotal. I don't claim any accuracy to it. But I think we all know that there really is a sizable population out there that hasn't done anything. And what is the consequence of that? Well, there can be a lot of consequences. We all learned in law school about the law of intestate succession. And generally speaking, the law of intestate succession will get your stuff to the people that you probably would want your stuff to get to. If you're charitably inclined, the law of intestate succession is not going to help you at all unless your favorite charity is the state of Hawaii. But you'd have to be the only child of two only children of two only children and be the last man standing in your family before there would actually be that escheat, the assets going to the state of Hawaii. So doing nothing really does nothing for your favorite charity, although it may get your stuff to the people you want it to get to. Recently came across a horror story of intestate succession and how it worked in one scenario that was kind of interesting. Uh, Fellow was married, had a child, and at some point in time decided he wanted to be married to somebody else. So he divorced wife number one, and they divvied up their assets. They went their separate ways. And many years later, wife number one died intestate. Now, wife had one child with her ex-husband. And so, because of the law of intestate succession, everything went to the child. So far, so good. Unfortunately, shortly after that, child died without a will. The law of intestate succession directed everything to her dad. Dad died shortly after that without a will, and the law directed everything to wife number two. So when wife number one, well, I guess you wouldn't say she realized, but if she could realize, when her husband, ex-husband, had inherited everything she probably turned over in her grave. And when the wife number two inherited all of her stuff, she was probably spinning in her grave. So the law of intestate succession doesn't always have good consequences for us and for our loved ones. So what if I do nothing? Well, at the very least, there's likely to be problems for the intellectuals in our families to solve. Is that what's best for me and my ohana? Well, that's up to you to decide. But if it's not, what should I do? Well, let's start with the concept of the planning pyramid. I'll just lay a little foundation here. Very often when clients come to see us, they know two things. They want to avoid probate, they want to avoid taxes. And those are both really good things to avoid if you can do it legally. But there are things that really are more important than simply avoiding probate and avoiding taxes. I know there are for me. And the number one thing is control. I want to be in control of my stuff for as long as I can. And I want to say who's going to take control if there comes a time when I can't be in control. So really what I consider the foundation of good estate planning is putting control in the hands of the people you want to be in control. Next step up is provide for me. Oh, and my spouse. Now, I have my spouse there in parentheses, not because my spouse is not important. She is. But it's for the same reason that when you take a plane trip and they give you the safety briefing at the beginning of the trip, they talk about the masks that can come down from the overhead compartments. And I know exactly what to do with the mask. They don't tell you to put it on the person next to you. They tell you to put it on yourself first before trying to help other people with their masks. And that's not because they want you to be selfish. It's because they want you to be conscious. They want you to be able to help the people around you. And estate planning is kind of like that in that you got to take care of yourself in order to be in a position to take care of the people who, figuratively speaking, are sitting around you. The next step up our pyramid is providing for other family members and then ultimately minimizing those taxes and expenses. But that's the last piece of the jigsaw puzzle. That's the tip of the pyramid, not the foundation. Because if you take care of those other priorities, the minimizing taxes and expenses piece pretty much falls into place. So given that planning pyramid, let's propose this definition of estate planning. First of all, I want to control my stuff while I'm alive and well. No objections there. I've never gotten one from anybody that I've shared this concept with. Point two, I want to plan for me and my loved ones if I become disabled. Now, the word if is in red there. I assume everybody's watching in color, to emphasize a point. According to the folks who sell long-term care insurance, and so, there may be a little bit of bias there, but approximately 70% of us are going to spend some amount of time completely incapacitated and needing some form of care before we die. 70% of us. So given that, obviously disability planning is something we should all focus on. And then ultimately, I want to give what I have to whom I want, when I want, the way I want. And when I die, and the word when is emphasized there because the odds, frankly, are a little bit higher than 70% that everybody within the sound of my voice is going to die someday. So when I die, I want my stuff to go to the people I love without unnecessary cost or delay or loss of privacy. So how do we do that? Well, one approach to estate planning is this thing called joint tenancy. Let's take a look using sort of a case study of Penny Wise and Buck Foolish. Penny and Buck are a married couple, have 3 sons, and they learned that joint tenancy is a way to pretty much automatically pass your stuff on to your loved ones after you die. And it's true, joint tenancy can work that way. And let's say, just for fun, that Penny and Buck have 3 sons named Mo, Larry, and Curly. And let's say that Penny and Buck put Mo, Larry, and Curly on title to their house, on their Makiki rental condo, on their car, their bank accounts, everything they own. They put it in joint tenancy with the three boys, thinking that dad, being the oldest, Buck is going to go first, right? And then Penny, and then the three sons are going to own it, and they can figure out what to do from there. So Penny and Buck put Mo, Larry, and Curly on title to all their stuff. Well, everything goes fine for a while until that fateful day when Mo comes running in the house. Mom, Dad, got a problem. Remember that car accident I was in about 3 years ago? Well, it turns out that the people in the accident, the other people in the accident sued me and they got a judgment. And now their lawyer has started to ask questions about what I own. And I seem to remember that you folks put me on title to your house and your condo and your car and your bank accounts and really everything you own. Do you think that's going to be a problem? Well, a couple minutes later, Larry comes running in. Mom, Dad, got a problem. My wife is leaving me. She wants a divorce, and she says she's going to take me for half of everything I own. Now, I don't really own much, but I think I remember you folks put me on title to the house, the condo, the car, the bank accounts, and pretty much all your other stuff. Gosh, do you think that's going to be a problem? Well, of course, we know that we got some problems here because now there's at least two people out there very motivated, very interested, very able to get into Penny and Buck's assets, possibly force a sale of the house, force a sale of the condo. So what started out being a wonderful idea was kind of wrecked by Mo's creditors and by Larry's ex-wife. Now remember that there were three sons. There was Mo, Larry, and Curly. Now, Curly falls into this very special category of beneficiaries, and you can go through the legal treatises and you're not going to find this specific legal term, but the term I like to use for these guys is the Babu's beneficiary. They may be very nice, very lovable, very wonderful folks, but they just don't have the ability to hold on to money. Maybe they've got bad friends, bad spouse, bad influences, bad habits. They just can't hold on to money. And one of the things that relying on joint tenancy can do is it sacrifices the opportunity to put protective measures in place for the folks in our families that we dearly love, but we know that if we leave them something, it's probably going to get wasted. So joint tenancy can be a wonderful thing. We use it in the estate planning process, but we use it very carefully and advisedly because of the obvious downsides. Now, the option to joint tenancy is just, well, own all of your stuff in your own name. Well, any individually owned assets that you have at the time of you die are going to pass in accordance with your will, whether it's a written document that you had a lawyer to prepare, or you went online and you had LegalZoom.com prepare it, or you just relied on the state's will that's already drafted, it's in the revised statutes. But if your stuff passes by way of will, it's got to go through this process called probate. And we all know that probate has some very distinct disadvantages. It costs money. It can take a long time. You got to deal with lawyers in the process. It provides an undue amount of publicity to your family and to your stuff that maybe you'd like to avoid. Now, current law allows us to redact certain documents or file them under seal so that a certain amount of privacy can be maintained. Social security numbers, dates of birth, account numbers, any official government certificates of death or birth or marriage and those kinds of things all can be filed under seal. But still, any other lawyers involved in the case have access to those documents. And potentially their clients have access to those documents. So can that give rise to bad results? You bet it can. Now, fortunately, the law has come up with a remedy to the problems posed by joint tenancy and by probate. And what that remedy is this thing called a trust. Now, the genius of a trust is it divides the ownership of our stuff between the title holding component, and the beneficial, or the equitable is another legal term, really the enjoyment component of the assets. Now, the elements of a trust are these. The first is the trust maker. Now, again, that's not a term you're going to see in any of the treatises, and people a lot smarter than me call this person the grantor or the settlor or the trustor. But I call it the trust maker just because it's kind of self-explanatory. So trust maker makes an agreement with a trustee to manage some stuff for the benefit of one or more beneficiaries. Now, under the law of Hawaii and really all 50 states, the same person can be trust maker and trustee and beneficiary of a trust. That's called a revocable living trust, generally speaking. Now, in order for the trust to exist in the first place, something has to change hands between the trust maker and the trustee. That's the stuff. And again, smarter people than I call the stuff the trust principal or the corpus or the trust assets. I call it the stuff just because you know what I mean when I use the term. And the agreement between the trust maker and the trustee is set out in the rule book, which again, smarter people call the trust instrument. So given all of those elements, you can have an arrangement whereby you avoid the downsides posed by joint tenancy, you avoid the downside posed by individual ownership and eventual probate. So let's talk about some of the specifics. Now, there's many, many kinds of trusts, of course. One general type is what we call testamentary trusts. And in Hawaii, we're aware of the Bishop Estate, which is a testamentary trust, the Campbell Estate, which was a testamentary trust. It's now terminated. Bishop Estate gets to continue because it's charitable, so charitable trusts can continue indefinitely. Under Hawaii law at the time James Campbell had his will done, you couldn't have a private trust that lasted forever, though under current law, you actually can. Testamentary trusts are wonderful for providing management of your assets after you're gone. But what do they do for you and your family while you're still alive? Well, they can't do anything because they don't even exist until you die and your will is admitted to probate. So again, testamentary trusts can have certain wonderful aspects to them, but as a general rule today, we don't use them at all. There's one very specialized area of Medicaid planning where we use testamentary trusts because that's the only way we can get the result we want. But generally speaking, we don't really use testamentary trusts anymore. We use living trusts. Now, living trusts break down into a lot of different categories as well, but two of the big ones are revocable and irrevocable. For the revocable trust, I want you to imagine a little red wagon. Now, a little red wagon is, a container that you can put stuff into, you can take stuff out of, and really, when you put things in, there's no limitation. You don't lose control over what you've put into your little red wagon. You can get at it anytime you want. The reason to have the little red wagon in the first place is so that you can protect your stuff from the downsides that we talked about of joint tenancy and individual ownership. Let's imagine you're walking through life with all of your stuff in your arms. Something bad happens. What happens to your stuff? Well, it ends up in a mess on the ground. If the reason for the mess is that you became incapacitated, then the person who cleans it up is called your conservator. And if you've done any work in the conservatorship area, you know that conservatorship really is probate on steroids. You have to go in, prove that on the public record that somebody's no longer able to manage their own stuff, which can be a battle all in and of itself. And then there are periodic accountings. And then when the person eventually dies, assuming they didn't have an estate plan set up before the conservatorship, well, all of their stuff goes through probate. So for the lawyers, it's winner, winner, chicken dinner. For the clients, they don't like it that much. Now, in contrast to the revocable trust, you have the irrevocable trust. And the irrevocable trust, I'd like you to imagine a little Lauhala box that you can actually put stuff into, but the box has a lid. And what the lid means is you don't have the same access as you did with the little red wagon. You can't reach in there any old time you want because there's a lid keeping you out. Now, the most common kind of irrevocable trust that I can think of is the irrevocable life insurance trust, which once upon a time we did primarily for tax planning purposes. Um, Now, with the exclusion that's allowed under federal law from the federal estate tax, and even from the Hawaii estate tax, uh, tax planning for most people is irrelevant. But there's still a really good reason to put your life insurance into the irrevocable trust. And again, as long as you set it up right, you get not only the potential tax benefits, but you get some other benefits as well. So let's say that I decide I'm going to buy a life insurance policy because I want to provide for my family after I'm gone. Let's say I'm the primary breadwinner or I'm a significant breadwinner in the family, and I want to have a way to be able to basically replace the bread that I'm bringing in the event something really bad happens to me. So the idea is I would go out, buy a life insurance policy, name my beneficiaries, and let's say in this case it's my wife. And then if I die, the policy pays off, my wife gets the money. So far, so good. But then one day, my wife is driving down the H1 and she happens to be distracted. She's expecting a text from our daughter, and she hears this noise coming from her phone. And of course, she would never do this in real life. But on this one occasion, she's tempted so much that she looks over at her phone to see the message from our daughter, looks back up to the road just in time to see the school bus that's pulled out in front of her. Bam, 27 kids on the school bus. And fortunately, none of them is severely injured, but my wife's car at this point is totaled. The school bus, of course, is damaged. And then there's all the precious cargo in the school bus that has damage on various levels as well. So with every one of those 27 kids, the left hand goes to the neck, the right hand goes to their cell phone, because every single one of them has one, and they call their moms and they say, "Mom, guess what just happened?" And how many of those moms do not know a personal injury attorney or how to get in touch with one? So now those insurance proceeds that I thought were going to be there for my family are actually there for those 27 precious children on the school bus and their lawyers. And don't forget, the school bus probably has a driver, probably has an adult chaperone or two. But the point is that what I thought was going to be there for my family ends up being there for everyone but. So what do I do to avoid that problem? Well, one of the kinds of things I can do is get that little La Hala box, the irrevocable trust, and actually have the irrevocable trust purchase the life insurance on me. And I would name the trust as the beneficiary of that life insurance. So now something really bad happens to me, the money doesn't go to my wife, it goes to the trustee of the trust to manage for the benefit of my family. So imagine the conversation I have with my wife when I say, "Hey, honey, I had a brilliant idea. And remember that life insurance policy we were going to buy? I did something better. I went out and I created this irrevocable trust that if something bad happens to me, the money's going to go into the trust. It's not going to go to you. It's going to go into the trust. And then the trust is going to take care of you and the family. What do you think?" Well, first question, of course, is who's the trustee? And let's say I can satisfy my wife that the trustee is somebody that she can trust and feel good about and all like that. But she says, "Now, how is that going to protect us?" And I said, "Well, see, the way it works is whatever you can touch, your creditors can touch." And we go through the school bus story, and my wife says, "Okay, yeah, I get the school bus story and stuff. But it sounds like I could go to that trustee and say, 'Please give me money.' And the trustee can tell me no. The trustee can have absolute discretion. In fact, what you described, the trustee has to have absolute discretion whether to make a distribution to me or not." And I said, "Yeah, hon, that's the way it has to work. The trustee has to be able to tell you no, because if you got sued and you got dragged in front of a court, And the court said, well, why don't you pay these people? You need to be able to say, I can't. It's all in the hands of the trustee, and the trustee has absolute discretion whether to make this payment or not. And the trustee just doesn't happen to be in the mood to pay creditors. Sorry, there's nothing I can do. So in order to have that creditor protection, that trustee needs to be a neutral third party, by which I only mean it cannot be beneficiary, beneficiary spouse, parent, descendant, sibling, employee. But it can be anybody else in the world. It can be beneficiary's best friend, cousin, uncle. It can be a bank or a trust company. So as long as the trustee is at least one step outside that inner circle, we've got that protection to make sure that the assets I thought were going to be there for my loved ones probably will be. Now, one problem that my family could encounter is that if the trustee locks down that irrevocable trust and says, no, I'm not going to pay creditors, if the trustee makes a distribution to one of the beneficiaries, the creditors can pounce on it. So the beneficiaries may have to live without any distributions from the trust. But if the trust owns a house that the beneficiary can live in, that may not be that horrible a thing. But you see, the point is that the beneficiary is not going to be able to get a distribution of cash out of the trust, just like the creditor is not going to be able to get a distribution of cash out of the trust. So what have I done? I've put my beneficiaries in a position to be able to go to the creditor and say, hey, look, there's money in this trust. You want some, I want some. But the fact is, the trustee is not going to give either of us anything unless we can come up with a reasonable solution to this pilikia between us. So let's get reasonable. Let's settle this thing. Let's get on with our lives. So that's what I've done for my family. I'm not trying to help them get away with anything. I'm trying to put them in the best possible position to resolve valid claims. So the irrevocable trust gives my family that opportunity, and that could be a reason in and of itself to create that irrevocable trust. And as I mentioned earlier, there are some wonderful tax planning reasons to use irrevocable trusts, though for most of us and most of my clients, frankly, the tax planning really is pretty much irrelevant. Well, let's talk about some estate planning strategies that we can accomplish by way of our trusts. The first one is incapacity protection. Now, I've seen a scenario where a senior family member developed a very serious disease, resulted in dementia, and what this individual did was shortly before he died, he made some very bad decisions with respect to his estate, and he took a large estate and made it a small estate, much to the chagrin of his family. Unfortunately, there was nobody who could step up and say, hey, granddad, sorry, but you really shouldn't be in control of things anymore. We gotta, protect you and us from this condition that you have that, it's not your fault or anything, but you're just not able to be a good trustee anymore. Now, most of the time, if you take a look at trust instruments, you'll see that there's some way of determining incapacity. But usually it's by way of a court order or it's by way of a doctor's determination. And what if your clients or what if you decide, well, yeah, but I'd rather this be a private thing. And I don't want to have to go to court to have dad declared incompetent. I want to have a way for dad to be able to be replaced as trustee, but have it be a family decision. And it doesn't necessarily have to be family. You can build into your, what I like to call disability panel, a set of individuals who you're just absolutely confident are only going to pull the plug on your trusteeship if you are absolutely confident that they're going to do it in your best interest and in your family's best interest. So the choices are take a chance on a judge, take a chance on a doctor, or have trusted family members making that determination. So having a disability panel made up of those trusted individuals can be a really neat option. Remarriage protection. I like to illustrate this with a story about Fred and Wilma. Now, Fred and Wilma are sitting on their back lanai one evening, and it's a beautiful time of evening. The sun has just gone down, the breeze has just started to pick up, the birds have found their nests in the trees. And Fred turns to Wilma and he says, Wilma, if I died, would you remarry? And Wilma says, what's going on? What's the matter? Fred says, no, 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 nothing. Everything's fine. Remember, I just had a checkup, blood pressure, cholesterol, all that stuff. That's all fine. It's not a health thing. It's just I've been thinking about this, and I want you to know this is important to me. I want you to know that if I die, it's perfectly fine with me if you remarry. And Wilma says, okay. A couple minutes later, Fred turns to her again and he says, Wilma, if I died and you remarried, would you let your new husband come and live in our house? And Wilma says, Fred, I was just kind of starting to enjoy it out here. Are you sure you want to spoil the evening like this? And Fred says, Wilma, I'm sorry. I just need you to know this is important. If I die and you remarry, it's perfectly fine with me if you have your new husband come and live in our house with you. Wilma, very irritated by this point, says, okay. A couple minutes later, Fred turns to her again and he says, Wilma, if I died, at this point, Wilma stands up. She says, Fred, I'm going in. You have now officially spoiled the evening. You can just enjoy it out here by yourself. And Fred says, no, no, wait, Wilma, please wait. This is important. I want you to know. If I die and you remarry, it's okay with me if your new husband uses my pickup truck. But I have one last question, promise. Last question. If I die and you remarry, will you let your new husband use my golf clubs? Wilma thinks for a minute and says, no, I really don't think I would. Fred says, really? Why? And Wilma says, well, for one thing, he's left-handed. Now, I don't golf, so I've not had the experience of having my wife answer a question quite like that. But you can see the point that with the proper planning, with the proper provisions built into your trust, you can say, hey, I want to provide for my spouse after I'm gone, whether my spouse gets remarried or not. But there might come a point when I want to say, we're going to cut it off there, and the assets are going to go on to the kids. They're not going to go on to the new husband and the new husband's kids to the exclusion of my kids. And I've seen that scenario play out more than once, and it's not a happy scenario. So among the kinds of things we can build into our trust is provision for remarriage and protect against the problems that can arise from that. Another way to avoid those problems, as Albert Einstein would. Creditor protection. We've talked about this. And with a revocable trust, the principle is pretty much the same as an irrevocable trust. So with your revocable trust, you can say, when I die, trust terminates, assets go out to my beneficiaries. And that's a very common approach. Let me propose a twist on that. How about saying, when I die, rather than my little red wagon just tipping over and everything going to my family, we put a lid on the little red wagon so that my revocable trust now starts acting like an irrevocable trust, so that maybe the beneficiaries can't get in there any old time they want, but the trustee can. The trustee can access those assets for the benefit of the beneficiaries, but the creditors, the predators, the people that I wouldn't want to have digging into my loved one's inheritance aren't going to be able to do that. So we've got creditor protection that we can build into our revocable trusts. Another thing is divorce protection, and the principle is the same, whereby we give assets to our loved ones, but we don't give them in the way that the loved ones have absolute control over them. We make sure that we've got that neutral third-party trustee to make distributions within the trustee's discretion so that the assets are going to be used by the people we want to have using them. Now, depending on how much control you want to give to your beneficiaries, you can make this scenario pretty palatable. I mean, having to go to a trustee every time you want money, that, doesn't sound like the most wonderful thing in the world. But what if you could give the beneficiary the power to say, trustee number one, Dad picked you and everything, and I think you're wonderful, but I'm tired of dealing with you. I'd rather deal with this person over here. So I want to fire you and replace you with another trustee. Can you give your beneficiary that power? Yes, you can, if you want to have them be able to exercise that level of control. Another thing you can do to make this very palatable to the beneficiaries is you can give them a power of appointment over the assets so that when they die, they get to say where any leftover assets go. They don't automatically go to the children, or they don't automatically go anywhere else that you would direct. The beneficiaries can actually direct where those assets go. So the beneficiaries can control the trust during their lifetime by way of that ability to hire and fire the trustee. They can control the trust at their death by way of that power of appointment, which pretty much gives them an awful lot of control, but it gives the creditors and the predators absolutely no control. So just stuff to consider. Another thing that we can take care of in our revocable trusts is planning for special needs individuals. Now, a lot of times we'll build in special needs language, even if there isn't an identified special needs beneficiary, but just in case, you never know. If someone is receiving governmental benefits, they can lose those benefits by inheriting too much in the way of assets. And very strictly speaking, too much means more than $2,000, which obviously isn't very much. So what you can do instead of leaving assets outright is you can build in sort of an emergency backup that says, well, if any of my beneficiaries are receiving governmental benefits that they would be disqualified from receiving if they inherit from me, then I want those assets set aside into what I like to call a supplemental needs trust that can be accessed for the beneficiary's well-being, can do all of the kinds of things that the government won't do. Buy them a new TV, buy them a computer, take them on a trip, buy them a new bed, just be able to enhance that beneficiary's quality of life without making distributions that supplant government benefits that would have the effect of disqualifying that person from receiving benefits in the first place. So special needs planning can be a pretty important component of our estate plans. Another kind of thing that we can consider doing is promoting our values through our estate plans. What do I mean by that? Well, one value might be, I don't want my beneficiary to take the money that I leave behind and use it on drugs or alcohol, other things that I don't think are a good idea. So we can build a carrot or a stick into our estate plans. By carrot, what I mean is we can encourage certain behaviors like, well, I think education is very important. I want my beneficiaries to be educated. So I can say, if I die while my children are still going through school, I want my trust to take care of their education. And not just through high school. I want them to be able to go to college. I want them to be able to go beyond in their education as well. So how do I encourage that? Well, one way you can do that is you can build in special bonuses along the way. And we've actually worked with clients and they've worked out the bonus system. But here's an example. When the child graduates from college, they get a distribution. And maybe it's enough to buy a car. When they graduate from graduate school, they get their master's, they get another bonus. When they get their doctorate, they get another bonus. Now, this doesn't guarantee, of course, that the kids are going to go to college, much less get a master's or a doctorate, but you can see how this would at least encourage the descendants to go down that road to education. As far as the stick, the other end of the spectrum, this is discouraging behavior. You can say, for example, if any beneficiary does not pass a drug test, they can't get a distribution. If they don't go through a rehab program, they don't get a distribution. Now, in practice, how well these kind of provisions work is really dependent upon how strict the trustee is going to be. And we'll talk about choice of trustee in a minute. But obviously, you're going to have to pick a very strong trustee to be able to stand up to a beneficiary to say, hey, before you get any distribution, you got to pass a drug test. You don't want to take a drug test? No problem. But you have to show me a drug test that you've passed in order to get a distribution. So it's up to the beneficiary to figure out whether they really want that distribution or not, and whether they're going to do what's necessary to get it. So those are just some ideas to bat around that you can build into your estate plan. We've talked about trust. Let's talk a little bit about planning for incapacity. One thing that I think everybody over the age of 18 in the state of Hawaii should have is an advanced healthcare directive. That's a document where you give someone else the power to make healthcare decisions for you in the event that you can't make and enunciate them for yourself. Really critical to have that in place, because the alternative can be litigation. The alternative can be just a really bad situation between family members. And your doctor at the same time really doesn't want to be in the position of having to tell the family, hey, it's time to pull the plug. So one of the kinds of things we can do is we can do an advanced healthcare directive that says, this is the list of people, starting with A, going to B, going to C, who can make decisions for me if I can't make them for myself when it comes to my person. So this person can choose my doctor. They can decide where I live. They can even go up to that ultimate decision, the God power, the ability to say, yes, it's time to pull the plug. And obviously, if you have an advance directive, you want to have more than one heart-to-heart with the people that you have as your substitute decision makers to make it very clear, these are the conditions under which I'd want to continue to live. And these are the conditions under which I really would prefer you pull the plug and just let me go. And those kinds of conditions can range from anything to, well, give me a little bit of time. Don't just have a hair trigger on pulling the plug, but don't go beyond a week or 2 weeks or whatever amount of time you feel comfortable with. You can also make sure that the people in line to make the decisions have not only the expertise, but the intestinal fortitude to make the decision. It's not an easy thing to say, go ahead and pull the plug on dad. So before you put that on somebody, you want to make darn sure that they're going to be able to make the right decision at the right time. Now, in your advance directive, you can give a lot of really specific instructions. And I've seen very specific advance directives that say things like, well, if the chances of my recovery are less than 70% or this, to go down that road is fraught with difficulty because we never know what the actual circumstances are going to be. So really what I think is a better approach is to just pick people that you know are going to do their best to make the right decision if and when the time comes, and just give them the discretion to figure it out. And you can give them as much guidance as you want. I mean, very few people would want to be kept alive on a tube. Very few people would want to be kept alive on a ventilator. If it was just a temporary thing, that's one thing. But if it's a long-term thing with no end in sight, a lot of people would say, shucks, at that point, just let me go, please. So these are the kinds of things you need to sort out in your own self and communicate your wishes to the folks that you would want to have making decisions for you. HIPAA is something that we need to be aware of. Now, in Hawaii, if you have an advanced healthcare directive, by and large, healthcare providers are going to assume that they have the authority to give information to your decision makers. Maybe not everyone in your family, but certainly the ones named in your advanced healthcare directive. But HIPAA in and of itself says that if someone has your protected health information and they give it to anybody without your specific written permission, they can be subject to substantial fines. They can even be subject to imprisonment. And I'm not aware of anyone being thrown in prison over HIPAA in the estate planning context. But you can imagine how medical providers are going to be very stingy with your information, and they're going to want to make darn sure that before they give information about you to anybody, they're going to have your authorization, or they're going to have very good legal basis for doing so. So one of the kinds of things you can build into your estate plan is what we call a HIPAA authorization. That's just a blanket authorization to healthcare providers to give information to the people listed in your advanced healthcare directive. And you can extend that list beyond the people named as your decision makers if you want. So you can say, well, I want all of my kids to be able to get information out of me or out of my healthcare providers, but I only want this child and this child to be able to make decisions for me. You get the point. Durable power of attorney is another one of those disability planning kinds of things that we do. And what the durable power of attorney does is give someone else the ability to deal with your stuff if you can't deal with it for yourself. And you don't have to be incapacitated for the durable power of attorney to come into play. But if you have an estate plan, and let's say you've got a revocable living trust as part of your estate plan, and unfortunately you didn't manage to get all of your assets into your trust before you died, or maybe you acquired something by way of inheritance or a lawsuit settlement or something like that shortly before you died. You never got the chance to put it into your trust. Well, the agent under your durable power of attorney can do that for you so that those assets don't need to go through probate. So that's one reason to have a durable power of attorney in place, to sort of be a backstop for the rest of your estate plan. Here's one that is really important for every single one of us. If you do not have long-term care insurance, try and figure out a way to either get it or make sure that long-term care for you is going to be funded somehow. If you've got enough assets all on your own not to need insurance, God bless you, that's wonderful. But if it's going to be a real strain on your family to pay for long-term care, there are a variety of solutions that your insurance professional, your financial professionals might be able to suggest. And I urge you, run, don't walk, to find out what those solutions might be and get them in place so you don't have your family in a position of having to try and figure out how to pay $25,000 a month for your care using money that they don't have. So paying for long-term care, again, really critical. All of us need to think very seriously about it. Well, let's just turn really quickly to estate taxation. As of 2025, the exclusion from estate tax is almost $14 million. That's the lifetime exclusion, which means for most of us, for most of our clients, estate tax is not an issue. Don't really have to worry about it. Another thing that happened at the same time the lifetime exclusion went up is the annual gift tax exclusion went up. So now it's $19,000. Last month, 2 months ago, rather, it was $18,000. Now it's $19,000. And that's important in that if you make a gift to your child of a penny more than $19,000, the law requires you to file a gift tax return on that gift. Now, given your $14 million exclusion, there's not going to be any tax to pay, but still you have the time and expense of filing a gift tax return. But as long as it's no more than $19,000 per recipient per year, there's no need to worry about estate tax consequences. Well, I've gone on for about 50 minutes, and we wanted to leave time for questions. So rather than continue with the outline at this point, I'm going to double check and see if there are any questions and go ahead and answer those. And then if time permits, get back to the outline. So actually, there are no questions. So great, I'll continue with the outline for now. The rate of the estate tax is a flat 40%. So the way it works is essentially if you own more than that $13.99 million worth of stuff and you leave it behind when you die and you don't give it all to charity, Congress wants 40% of the excess over and above that exclusion amount. Sorry, I'm having a hard time advancing the screen here. Oops. We're frozen up. The due date for the estate tax return and the payment of any tax that's due is within 9 months of date of death. So in an estate that's real estate rich, cash poor, that can be a real issue. That is the liquidity of the estate, because the IRS wants cash. They don't want chickens. They don't want real estate. They want cash. And if you can't pay it, no problem. You can work something out. You can get an extension, but there's going to be interest and penalties associated with that. One really neat thing that came in, this is actually during the Obama administration, is something called portability. And that means that if I have a relatively small estate, but my spouse has a relatively large estate, I can give them the unused portion of my lifetime exclusion so that if I can't use it all up during my lifetime, maybe they can use it up upon their death. And all you have to do is file an estate tax return, and that exclusion passes on, that timely filed estate tax return. And Hawaii, like the feds, has its own estate tax, and it can be a little bit sneaky in that Hawaii doesn't have a gift tax. But if you make taxable gifts during your lifetime, even if they're covered by your federal exclusion, what the state does is they add those gifts back to your estate, and that increases the size of your estate potentially to the point where you may go over that $5.5 million, and you may have to, or your loved ones may have to pay some estate tax. The Hawaii exclusion is not adjusted for inflation the same way the federal exclusion is. And the federal exclusion, by the way, is set to sunset at the end of this year, so that as of the beginning of next year, unless Congress does something in the meantime, that exclusion is going to go from approximately 14 million down to probably about 7 million. It's going to revert to the pre-law that made this annual increasing extension actually get to be so big. So we'd go to the law of 10 years ago and apply the law that was in effect then. And hopefully Congress will act in the meantime. And my best guess is that they probably will. Congressmen have, some of them have pretty big estates themselves. And so they probably would like to see that regime, that estate tax regime, continue. Would also love to see the state get on board. There was a time when the state basically mirrored the feds in terms of that exclusion, so that if there was no federal estate tax, there was no state estate tax either. But then about 5 or 7 years ago, our state decided now we're going to go a different direction. And so we've got our own separate exclusion that's not indexed for inflation. And this last legislative session, a bill went all the way through. It got to conference committee even, that would have basically caused the Hawaii law to march in lockstep with the federal law in terms of the exclusion. It was not ultimately enacted. I don't know whether there's any planned this legislative session for that to be reconsidered, but it would be great if they did. It would really simplify things for a lot of folks. And, you know, the really big estates don't pay estate tax, at least not to the state of Hawaii. If you think of Zuckerberg or Benioff or, you know, Uncle Larry over on Lanai, none of those folks are probably paying Hawaii estate tax. So there's no need for us to have a really small estate tax exclusion relative to the federal exclusion that's going to mostly impact Hawaii residents as opposed to the really rich folks who come in from the outside. Choosing a trustee is...
Sorry, Scott. I think we have a
Yeah,
couple questions in the chat.
great.
What are the pros and cons of a transfer on death deed?
Transfer on death deed can be a really effective way to hold on to your stuff during your lifetime, but have it transfer upon your death. Now, a transfer on death deed avoids probate, so that's a huge pro. A huge con is that transfer on death deed doesn't do anything in terms of creditor protection for you or your loved ones, either during your life or after you're gone. So As a general rule, I'm not real keen on transfer on death deeds, but they can be a very effective way for an individual to hold on to control during their lifetime. The person who's granted that transfer on death deed doesn't have to worry about the same kind of issues that faced Penny and Buck at the very beginning of the presentation, because the creditors of the transfer on death beneficiary, at least during our lifetimes, aren't going to be able to touch that property. So it's a probate avoidance device that can be really great in the right circumstance.
Okay, just a friendly reminder, if you have any questions, feel free to put it in the Q&A box.
Okay, so I've got about 2 minutes left. Let me just talk a little bit about choice of trustee. As I was starting to say, this can be the most important decision you make in the estate planning process because your trustee is going to make or break your estate plan. You pick the right trustee, all will go well. And the right trustee is just someone who's willing to read your trust instrument, your rule book, and most importantly, follow it. Obviously, you want someone who's honest. They're not going to have their hand in the cookie jar and like that. Um, but generally speaking, this person does not have to be a lawyer or an accountant or have any special qualifications other than being honest, being willing to read the trust instrument, the rule book, and follow it. And then a trustee can be an individual, can be a bank or a trust company. You can have co-trustees. You can have sort of a board of trustees if you think that's going to work best. The independent distribution trustees would be the ones that come into play if you're going to build creditor protection into your trust. So this would be the person who's not a beneficiary, nor the beneficiary spouse, parent, descendant, sibling, employee. Another thing that can be super helpful to build into your estate plan is provision for a trust protector. What a trust protector is your designated problem solver who can go in and appoint a trustee if one needs to be appointed and your trust agreement doesn't have enough people named. Let's say all of your chosen trustees either don't survive you or they don't want to be trustee when the time comes. Trust protector can appoint a trustee. Or if a really bad trustee ends up being the trustee, trust protector can remove them and replace them. So given that time's up, let me just whip through to the end and say, well, we know that if we do nothing, there's going to be problems to solve with our estate plans. So that's what is best? Well, probably not for most people. So what should I do? Well, plan to avoid those problems. Remember that quote from Einstein that an intellectual solves problems, whereas a genius avoids them. So given that mindset, congratulations, you are now a genius. So Desmond, thank you very much. I can stick around for a little bit if people have questions. If people have questions that they'd like to email me, my email address is the first four letters of my last name, MAKU, at Estate Planning, spelled EST, the numeral 8, planning.com. Did any questions creep in under the wire there, Desmond?
Yes, I'm just pulling it up right now. So I have a question that says, what determines what state estate tax is relevant for your trust or assets?
Great question. The state law that determines is probably the law where the assets are located. So Hawaii is going to have jurisdiction over any real estate located here. If you're a Hawaii resident, it's probably going to have jurisdiction over your intangible assets, your bank accounts, your investment accounts, no matter where they're located. And you know where money is located is sort of an odd concept. But if your bank account is with Bank of America and there are no branches in Hawaii, Hawaii law is nevertheless probably going to apply with respect to that account. Now, one thing about dealing with mainland financial institutions, even if the asset itself is deemed to be a Hawaii asset, is it can be extremely problematic to go to them and say, this is a Hawaii asset. So for one thing, because it's less than $100,000, we can collect it by way of affidavit. It's not uncommon for the mainland financial institution to say, oh, that's interesting. Let me see the court order. And you end up having to do a probate just to get that mainland asset if it's substantial enough, even though technically it's a Hawaii asset. So real estate located on the mainland would probably be subject to the mainland's real estate tax regime. And about half of the states have estate tax or inheritance tax or something that could grab some of those assets. So really important to consider if you've got assets spread out all over the place, that there could be multiple jurisdictions that could be involved estate tax wise. Other questions?
Yes. Okay, next question. If there are estate slash gift taxes, does it come from the estate or is it the responsibility of the beneficiary?
Great question. Primary responsibility comes from the estate or the transferor. But if the estate is all distributed and there were estate taxes due, don't think the IRS isn't going to go after the people who got those assets to collect the tax. So primary responsibility would be on the transferor, so it would be the estate, or if it's someone making a gift, the donor. But that wouldn't prevent the IRS from going after the recipients.
Okay, next question. Does the trustee have to pay claims by creditors against the estate or before he or she distributes to the beneficiaries?
Yeah, as a general rule, yes, the trustee really needs to pay the decedent's bills before moving on. So the trustee, let's say there is no probate because everything was in the person's trust. They set up their estate plan correctly and they got it properly funded. Nevertheless, there's going to be probably a final income tax that's going to need to be prepared and filed and taxes paid. And other claims against the decedent, the person who passed on, are going to need to be paid as well before the assets go out to the beneficiaries. And the trustee, the fiduciary involved, could end up being personally liable if they don't take care of those liabilities before they make the distributions to the beneficiaries.
Okay,
Any
next, we got about two more that we can answer. Can an estate created after the death of the individual create an irrevocable trust using assets from the estate?
Well, sure. If you wanted to do a testamentary trust in your will, that would work like an irrevocable trust. You bet you can. If let's say someone passes and they don't have a will, or they have a will that doesn't have any testamentary trust provisions in it, well, those assets can be put into an irrevocable trust, but there would be a whole other set of issues involved. So really, the best way to do the irrevocable trust planning is through the trust before the person dies. Quick answer, sorry.
Okay. And then we'll take this final question here. If anyone has any questions in the Q&A box, you can I put Scott's email in the chat box that you can email him directly as well. But this final question we can get to is what is your advice to new attorneys who want to specialize in this area? What missteps should be avoided?
All of them. Avoid all of the missteps. Um, well, I think it's probably really helpful, especially in the estate planning area, to hook yourself up with someone who's experienced and sort of be their apprentice and have them sort of coach you through the process. They don't require you to take any estate tax courses or wills and trusts or anything like that in order to graduate from law school. So you can get out of law school even being very interested in estate planning, but know absolutely nothing about it. And there are a lot of potential traps out there, pitfalls that you don't want to fall into. And essentially being mentored by someone can go a long way to helping you avoid those. Another kind of thing you can do is join the Probate and Estate Planning Section of the Bar Association. There are people in the Probate and Estate Planning Section who can either mentor you, or the section also provides programs for you to be able to learn as much as you can about estate planning through the monthly meetings of the section. So I'd really encourage you to get involved in the section and also find a mentor. preferably someone who's going to be able to look over your work very carefully, not just someone that you consult from time to time and take it from there.
All right. And like I said, if anyone has any questions that we didn't get to, Scott McCulkani's email is in the chat box, so you can copy and paste and you can email your questions to him directly. With that being said, thank you, Scott, for your presentation today for the February coffee hour. And then next we'll be back on March 6th for our upcoming coffee hour with Martha Clopin on excuse me for oh sorry I'm looking for trying to find the topic here.
Uh, is
It's
it
on,
Medicare?
yeah, it's on Medicare. Yes, you're right, Scott. Yes. Yes, on Medicare. So with that being said, thank you for attending, everyone, and we hope to see you in March. And thank you again, Scott.
We hope.